Welcome to the Quadrant LISW Debate on New Horizons in Trade Finance and Decarbonisation. First of all, I'll introduce the panel. We've got Simon Rainey KC at the extreme right here, Mr. Robert Thomas KC, Ruth Hosking, and Koye. Akoni, sorry.
I'm really sitting at the extreme right. I'm not an extreme right.
I did realize when I said that might be taken the wrong way. So a couple of housekeeping matters. Please, for those online, please do send in your questions and I will receive them and I'll be able to ask members of the panel. Those who are asking questions here, please put your hand up because we need to give you the microphone so that people watching online can hear your questions as well. And finally, please remember we have our Quadrant reception at 6 p.m. this evening. You've all been invited. I hope you all have your RSVPs in, and if not, please mention it to Sarah Longdon, who's at the back there, and we'll make sure we have you logged in. We hope to see you. So what are we talking about today? What unites the two topics? And it's really a question of risk allocation. You'll see that the first debate that we have is concerned with the allocation of risk between ship owners and bankers, and who has the risk of a fraudulent trader or an insolvent trader. Is it the bank whose customer that trader is, or is it the ship owner whose charterer or subcharterer it is, and from whom it has accepted an LOI? So that's what the first part of our talk's about. The second part of our talk's about decarbonisation, which, as you all know, is a very hot topic with many developments. And again, the new regulations that are coming both from the EU and the IMO create additional costs. And the question becomes, who bears those as between charterers and owners? And those are matters that both Simon and Koye will be discussing. So first of all, we're going to start with the Unicredit and Euronav, or as I'll call it, the Sienna, which was the ship involved. I'll give a very brief summary of the underlying facts, which some of you will know in any event. The owners, Euronav, voyage chartered the vessel to BP, and bills of lading for the carriage of fuel oil were issued to BP. So BP was the charterer and it was also the bill of lading holder. BP had on-sold the cargo to Gulf Petrochem, and that sale, the purchase price was paid by way of a letter of credit issued by Unicredit, which was the bank that was financing that transaction. At around the same time as the payment was made, Gulf Petrochem, BP, and Euronav entered into a novation agreement under which Gulf Petrochem replaced BP as the charterer, not ab initio, but from the date of the contract. As I said, the payment was made, and in accordance with normal practice, Gulf Petrochem issued an LOI, pursuant to which Euronav discharged and delivered the cargo. The bills of lading were then endorsed. They came through the chain to BP, and BP endorsed them to Unicredit, as BP had been asked to do by Gulf Petrochem. In the meantime, a massive fraud was discovered within Gulf Petrochem, and you will have seen many cases. I was involved in some of them, in which flew out of that fraud. So in the usual event, Unicredit, with the bill of lading in its hand, sued the owner, claiming misdelivery. And the owner, of course, would normally rely on its LOI, which it had got from Gulf Petrochem, but Gulf Petrochem's not worth anything. So the owner defended the claim under the LOI. There were two issues First of all, whether Unicredit had title to sue. And secondly, even if it did have title to sue, whether the misdelivery had caused Unicredit any loss. At first instance, Mrs. Justice Mulder held that Unicredit had no title to sue because the bill of lading in BP's hands was a receipt and remained a receipt even after BP ceased to be a charterer. There was at first instance no discussion about the applicability of Section 2 of COXA. But she also held that in any event, Unicredit's claim would fail because if the owners had asked Unicredit, you're the bill of lading holder, what do you want us to do with the oil? Surprisingly, Unicredit wouldn't have said, come and deliver it to our branch over there. They would have said, give it to our customer. It went on appeal. On appeal, Lord Justice Popplewell, delivering the judgment of the Court of Appeal, allowed the appeal on the first issue, held that when BP ceased to be a charterer, the bill of lading contract, which up to that point had been a mere receipt, sprung up into a contract. And in any event, Section 2 of COXA gave Unicredit title to sue. But he upheld the finding that there was no causation. And that's the background against which both Rob and Ruth will be discussing the case.
Well, thanks to Chirag for his introduction and welcome to everybody. In this first section, Ruth and I are going to pick up on some of the answers that the court gave to some of the issues and also look at some questions that it didn't answer and other issues that might arise in due course out of this decision. And we very much look forward to hearing any views from the audience on those issues in due course. Now, as Chirag has indicated and as an overview, the case can really be split into two sections. First is really the nature and status of the bill of lading, and the second is the question of causation. We'll have a look at both and hopefully we'll indicate when we're transitioning so we don't lose you in the process. So looking first at the bill of lading, I think where the case is potentially important is it's the first time the English court has rationalised the basis of the mere receipt rule. If you look at any of the still current textbooks, they will often say that the basis is either obscure or difficult to identify, or they'll simply say it's a convenient legal fiction. But what the court has done in our case, it's analysed that wherein what is the conventional situation of a charterer taking a bill and then negotiating to a third party, it's said that both the mere receipt principle and the springing up of the contract when that bill is endorsed is based on the presumed intentions of the parties. And it says quite logically that if that's so, then in the situation where the bill of lading remains in the hands of the charterer, but the charterer ceases to be charterer, the same principle, I presumed intention, should apply to determine the outcome. The court then continued, and it characterised the mere receipt principle as follows. It said in issuing the bill of lading, the carrier usually contracts with the holder on those terms, i.e. the bill of lading terms, save only for so long as the holder is a charterer, and save to the extent thereafter the contractual relationship with the carrier for the performance of the carriage remains governed by the charter party. Quite a long explanation, but that accurately describes the position as the court saw it. In other words, what it said was that the bill will not otherwise be a mere receipt, but will contain or evidence the relevant contract of carriage. And again, that was said to be based on the presumed intention of the parties. So what happened in our case, the Court of Appeal said that the mere receipt principle prima facie applied to render the bill of lading contract between BP, to render the bill of lading a contract of carriage between BP and owners when the charter parties cease to perform that function between those two entities.
So it's all very well. The court has for the first time rationalised it, but is presumed intention any more useful or a better yardstick than accepting it just being a complete and convenient legal fiction? It still requires an evaluation of what is, quotes, presumed intentions. And in all likelihood, in the real world, it is not something that anyone has ever really addressed their mind to. And in this case, as it shows, it could have ultimately been decided in different ways. It seems to be based on an idea of a strong presumption that goods carried at sea are to be done so pursuant to a contract and not anything else, and a universal knowledge and recognition in commercial and shipping circles that bills of lading usually provide you with the terms of that contract. And so there we are. That's the basis of the presumed intention. So on the one hand, personally, I'm not sure it is much more useful than saying it's a legal fiction. But on the other hand, presumed intention is something that we see legally elsewhere. And so in that sense, it's familiar principles. Rob, do you think it gives you any better degree of certainty than you have before?
My view is not. I think, as Ruth indicated, that exercise of identifying presumed intention still requires an assessment of the evidence, the documents, and what you draw from them. And certainly on one view, at least, maybe a slightly cynical one, it does little more than permit the court to impose what it considers to be the sensible solution to the particular problem.
Although it's always a bit difficult, because what a court perceives to be a sensible solution isn't necessarily what the market and end users think is a sensible solution. And often the market's perception is that the court doesn't properly take its considerations into account when reaching that sort of decision. So we're going to move slightly away from presumed intention and see what you can do if something like that is put up against you. So the Court of Appeal was keen to stress that although there are presumed intentions, they are always, quote, subject to contrary agreement or circumstances which can demonstrate a contrary intention. And it strikes me, at least, that you're only really going to get that if you've got an express agreement, that something implicit is not going to be enough. I don't know if you agree with that, Rob?
If we look at the facts here, and again, if you've read the case, you'll see that the Court of Appeal put a lot of reliance on clause 30.7 of the Charter Party, which had the express provision that Gulf charterers could require discharge without the bill of lading against an LOI. And the court said, the Court of Appeals held that was a clear provision which foresaw the provision of an LOI, and therefore the bill of lading have the status as a contractual document. But if you set that to one side and imagine a charter party with no clause 30.7, so no provision of that sort, and a situation whereas actually in this case, the charter party novation has changed the permitted discharge ports. Now, on one view, certainly it seems to me that change of the discharge ports, so they were potentially different from those provided in the bill of lading, would give rise to a contrary intention. The Court of Appeal, however, didn't seem particularly bothered or indeed interested in that particular submission, and I'm not even sure it featured in the judgment. So when you look at it from that perspective, I think Ruth's right. I'm struggling to see circumstances absent express agreement where the court might be willing to infer the contrary intention as set out in its own test. And I guess more broadly, in any case where the charter party foresees the issue of a bill of lading, I'm doubtful that it will be possible to infer a contrary intention in any situation other than express wording.
I mean, Rob's hit on one of the things that I think is a bit of an oddity in the case, is that the court was not interested in the fact that the bills, i.e. the contract, provided for a discharge port that had now agreed not to be a discharge port. And yet there's no discussion of that anyway.
And one of the other oddities, and this feels like a Supreme Court point for Mr. Rainey, I'm sure, in due course, but
Very happy to take over any stage.
but I do wonder how this analysis interacts with Section 2 of COGSA itself. As many of you will know, Section 2 expressly provides that the subsequent holder of a bill of lading it has transferred and vested in it all the rights of suit under the contract as if it had been a party to that contract. Now, if you take a step back, two possibilities. Section 2 effectively overrides this search for presumed intent, and under Section 2, the bill of lading will always provide the subsequent holder with the rights. Alternatively, there may be an argument that if you can find that contrary indication, so you say, well, there's no presumed intention that the bill of lading will be a contract of carriage, does that render that bill not a bill of lading for the purposes of COGSA? Throw it out there. Answers on a postcard. Difficult issue, obviously not touched upon in the judgment, but it's one of the questions that might arise in due course. Another issue I think that is of potential importance going forward is that of waiver. Some questions weren't answered by the Court of Appeal, as I mentioned, and one of them is this. An issue arose as the possible effect of a waiver by BP when holder of the bill of lading on the rights of the bank, which became holder only after discharge. The Court of Appeal, having looked at the cases, held that a waiver by a shipper or charterer cannot bind the endorsee in whose hands the bill of lading contract springs up. It left open the wider and potentially significant question, which had been raised in the Duke and Ward, as to whether any waiver by the bill of lading holder binds a subsequent endorsee. And it expressed some doubt on that question. Now, if we take this in turn, it seems to me that the notion that a charter or shipper, an action by the charter or shipper, won't bind an endorsee of the bill of lading seems uncontroversial. If in that scenario you're not party to that particular contract, then that doesn't seem to me to be in accordance, anything other than in accordance with first principles. But the notion that where the waiving party is a contracting party to the bill at the time of the act of waiver, a subsequent holder may not be bound by that seems to me more problematic. And for my part, I would actually question whether it's in anybody's interests, because on the one hand, the owner is not going to be able to rely on what may be a perfectly sensible commercial agreement to change the parameters of the bill of lading, but also it may be unwilling to do so, because if it realizes it's not going to be able to rely on that particular waiver in due course, it may feel unable to accommodate a sensible commercial request from its counterparty. So there's certainly big issues that arise in that context.
I mean, I suppose the contrary view is that a third party taking a bill of lading in good faith could potentially suffer severe prejudice by reason of actions of which it, one, wasn't aware, and two, could never become aware of. Although I suppose arguing against myself, that's not very different from the fact that most bills incorporate the terms of a charter party that a subsequent third party has never seen. And therefore, it's not that different in that sense.
I mean, another issue, I suppose, that arises, and again, was raised before the Court of Appeal but not addressed, is whether that subsequent holder of the bill might have an action against the party who originally held it and whose waiver he is confronted with. Again, there's different angles to this, so that's another possibility for another day. So that is a little look at the aspects relating to nature and status of the bill of lading. If we turn to the issue of causation, it's clearly this part of the judgment which has caused most comment in articles and so forth. And what the judge found and the Court of Appeal upheld is that the bank would have authorised discharge in any event, so there was actually no loss suffered as a result of the breach. Now, in this context, to frame the debate, it's important to understand that the breach is delivery without the bill of lading per se, not delivery to the wrong party. And that's important because what the bank argued, they said, well, discharge against LOIs without production of bill of lading is common in trade finance, where typically the buyer's bank takes a security interest over the bill, usually a pledge, and becoming the lawful holder of the bill of lading, it retains that as security for payment either by the buyer or, in this case, the sub-buyers. That's what it said, was that the bill, whilst permitting, retaining the bill whilst permitting discharge against the LOI is, to quote, an essential aspect of such trade financing, because of the way it understood the bill was security for non-payment. Now, it seems to me, and I'd be interested in everybody else's view, that the bank's approach or understanding and the practice of relying on these bills as security in this form is something for which the bill of lading was not certainly originally intended. And I do also wonder whether the bank's practice and the way they regard this as security doesn't, to some degree at least, misunderstand the nature of the bill of lading rights that they're actually acquiring.
I mean, if we go back to Bill of Ladings 101, we're all taught that the Bill of Lading has three potential functions. It's a receipt, it sets out the terms of the contract, and then it's a document for the title of the goods. In none of that is it anticipated that it's going to be essentially a security that a bank can enforce after discharge. So I agree that in many ways the bill is probably being used in the market in a way in which it wasn't originally intended. But in trades like this, where owners and their P&I clubs are happy about it, I mean, why shouldn't they do it? And it's an area where the court and commercial practice seem to have diverged. So it was argued for the bank that the judge's conclusions at first instance would have, quote, calamitous consequences for those providing commodity trade finance, because it would be open to an owner in almost every case where discharge took place against an LOI without production of the bills to assert a similar causation defence. And it's certainly the thing that's caused an awful lot of commentary online. The Court of Appeal's response was, well, if that's so, it's simply the result of the application of conventional principles to which, quotes, the practical consequences for market practice must yield, i.e. we're right, the market needs to go and sort itself out. The court was very keen to stress that there are other forms of security available to the bank. And actually, in this particular case, the bank already had a 90% insurance policy, which it had been assigned. So it did have another avenue to recoup some of its money. I think what's most interesting about this debate in relation to trade finance is that really it does come down to allocation of risk. You know, if the bank had been right and it had been able to enforce its claim against the owners, it would have been paid $24 million by the owners, and owners would then have had to have sought to reclaim that money under an LOI with a fraudster and therefore not get their money back. And I guess I would ask, should it really be the bank's risk when it's the bank's customer that's gone bust, or should it be the owner's risk? And personally, I think it probably should be the bank's risk. And we'll come to think about risk allocation when we come on to think about the impact that the Electronic Bills Act may have in due course. But I think for now, I'm going to ask Rob some questions about burden of proof and evidence, because that was another aspect that the Court of Appeal was keen to show. So to establish causation, it was for the bank to show on the balance of probabilities that it would have enforced the security against the cargo so as to recoup its lending. Otherwise, there wasn't an effective cause of the loss, and failure to recoup the money would have happened in any event. And that causation defence requires an assessment of what would have happened had the owners initially refused to discharge and sought instructions from the bank. Mulder at first instance relied on the evidence of the bank's relationship manager with Gulf and found that it was either implicit or expressly approved discharge without production of the bills of lading. So the question I'm going to ask Rob is, what sort of evidence do you think it might have needed to prove causative breach as opposed to this non-causative breach that we have?
Well, the answer any lawyer will give you, it depends on the facts of the case. So in a more direct answer, of course, as an application of the general principles of breach and causation, the bank will need to adduce whatever evidence is appropriate in the case to prove that it wouldn't otherwise have suffered that loss. Now, this case is a good example. The bank had an elaborate set of evidence to prove its loss was 24 million, because at the time the bill of lading, sorry, the time the cargo was discharged, the commodity price had halved. So if you applied a normal rule of what's the value of the cargo at the date of breach, it would have been half. So they produced a ream of evidence, 3 witnesses, all sorts of other evidence to show that it would have taken them 3 months to actually work out what had happened and sell the cargo, by which time, of course, the commodity price had miraculously increased. So that was that's an example of looking at the facts to see what's required. But whether in most straightforward cases the banks will actually have to do very much is, in my view, unclear. The Court of Appeal observed that there are likely to be very few cases where owners know who the holder is or know who the subsequent holder might be. And there'll be still fewer cases where the owners actually have a practical a chance of communicating with those people. And in that case, the indication is the bank will have to do very little. It may also be of significance that Lord Justice Popple went on to say that in those circumstances, it may be unrealistic for such owners to establish they would have sought and received instructions to discharge from the holder. There's more than a hint there that the burden isn't going to be purely on the banks, but also on owners to advance a realistic case to support, if you like, the negative. So that's something I can see being debated in future cases, exactly where the onus lies, not necessarily legally, but evidentially in terms of proving or disproving a loss. Which brings me on to the question is whether this case is if this case practically changes anything. The Court of Appeal questioned whether there were any really far-reaching consequences, and they said it was very much the result of particular findings and the instructions in that particular case. I tend to share their view that this really does much to change the overall view of the world from the bank's perspective. But I don't know, Ruth, whether
I'm not
you
sure
agree.
I agree with that. I think if the bank is right and trade finance is done like this often, which it seems to be, then it doesn't seem that surprising that there'll be more cases where this sort of thing will have happened. And so I'm not sure that the facts are that unusual.
Only time will tell.
Just quickly before Chirag cuts us off, will the electronic bills change anything? So as many of you probably know, the Electronic Documents Act of 2023 received royal assent at the end of July, and it comes into force next week on the 20th of September. Section 3 expressly provides that electronic trade documents, which include bills of lading, will be capable of being possessed as a matter of law and will have the same basis and equivalency as a paper document. BIMCO's launched a 25 by 25, which is essentially a pledge that certainly in relation to the bulk sector, 25% of carriage will be done pursuant to electronic bills of lading by 2025. So if we have electronic bills of lading in more regular use, is it going to make a difference to this sort of a case?
In theory, the bill of lading would have progressed much quicker, and the bank would in all likelihood have been, in our case, would have been holder at the time of discharge. Will it change the bank's behaviour? Well, if they regard these documents as some form of security, I can't see any reason why they would change their behaviour. I wonder, however, if owners might wake up to what's going on and say, well, if these documents are available, why aren't they being presented? And that may be where the real change lies. So, thank you very much for your attention. I'm sure Chirag will open the floor to questions.
I'm going to open the floor to questions. So please put your hand up so that Sarah can come by and give you the microphone so everybody can hear you. Well, I'll start off on the causation front, because I did read Lord Justice Popplewell downplaying the effects of the causation decision. But I mean, I was involved in a lot of the Gulf Petrochem, and what's important is that the discharge happens at a time when nobody knows that the bank's customer is insolvent or a fraudster. And in those circumstances, if you ask yourselves, what would Unicredit have said? They would not have said, come and bring it up, bring the oil in some tankers up to our branch in Geneva. Right, they would have said, give it to our client so our client can give it to the sub buyer and we can get paid. Don't be stupid. Right? Isn't that what they would have said? And any bank asked, right? They say, well, okay, the way it works is you give it to my client and they give it to their buyer and I get paid. But they don't want the oil, do they? James has got an answer to that.
Well, Mr. Tricky question.
Yeah.
Actually working, yes. I don't really have an answer as much as a question. I'll make sure I've understood the facts, because if the bank would always have said, deliver to my customer, but it would only have said that because it had the security of the bill of lading, then why does it matter that it would always have said, deliver to my customer? because the only reason it would have said that is because it was sitting on what it thought was the security of the bill of lading. And I don't, it's probably my misunderstanding, but I don't at the moment understand why that rather obvious circularity of reasoning didn't dawn on the Court of Appeal. But I'm probably missing something.
Well, I think you have to go back to the facts of this case, and it doesn't come out very clearly in the Court of Appeal judgment, but in the first instance judgment, because they advanced this quite elaborate exercise of explaining what they would have done this quite elaborate exercise of explaining what they did, what they were actually saying. So, well, actually, if you come to us, that they'd originally said that actually we were expecting this to be discharged into the gyro. The original plan was for it to go into storage tanks, and they would take receipts for this storage, which is a conventional way of having security in a different form. Then the vessel didn't go to the gyro, but went up to a different location, and there was STS transfers. Now they said that, oh well, if we'd been made aware that this was happening, we would have smelt the proverbial rat. And in those circumstances, we wouldn't have allowed you to discharge the cargo to the STS vessels, and therefore our cargo over which we have a pledge would have still been there. So there was a rather more elaborate factual background to this. And the simple fact of the matter is that the evidence which the judge accepted was that, you know, whatever the circumstances, the bank was sufficiently interested in receiving payment, which was conditional on the sub-buyers taking the cargo, and then there was 90 days and all the rest of it. There was sufficient that they would have effectively agreed to anything. And the scenario was, if we as owners had come saying we will not discharge without the bills of lading, they would have effectively waived their rights as holders of the bills to provide those bills. So it's a little bit more complicated than I think the Court of Appeal judgment's a little bit truncated in that part of the analysis, but that's how it arose, and that's what Mrs. Justice Mulder found at first instance.
We have a question online. On the question of risk allocation, if a bill of lading is a document of title, can a holder be deprived of title so easily? An LOI presumes that the bill of lading is important. Terms provide that the bill of lading will be delivered when available.
That's a good question. Yes, I think often when we think about a misdelivery case, we're often thinking about it going to we're thinking about a fraudster turning up with a fake bill and guessing delivery. I think what we forget often is that when you deliver against an LOI, you are still technically committing a breach, because it's a breach in the failure to deliver against a bill of lading. And obviously that's the question where waiver comes up. Yes, it is a document of title, but I don't think that's what the banks are using it for, because they don't really want the cargo. What they want is the money, and that's why they've kept the bill. I don't know if Rob agrees.
Yes, I think in that position, I mean, technically the bank still has title to the cargo. They just nobody could find the cargo. And one of the many issues in this case was where was the cargo? Did anybody know? Could anybody find it, and so forth? So
the answer presumably was no.
Not that we ever found.
We've got one question here. Yeah.
My question is to Ruth, and I hear you saying that the bill of lading is not, strictly speaking, or cannot really be used as a security document because that's not the basic feature. But do you think there's a jurisprudential argument to be made that if it's a title document, inherent in any title document would be the ability to use it as security documents, because you always can assign legal or equitable interest in any document that has title?
I think there is, and I think there is going to be debate about that in future cases. I think potentially the most interesting aspect of this is what owners are going to do, having now read this judgment and thought about maybe the Electronic Documents Act, because I think originally everybody thought the reason that LOIs were needed was essentially because it took a really long time for paper documents to get around the world, and transport has got much quicker. And so by the time your cargo ends up in Fujairah or wherever, it's very rare that a bill would ever have made it there. I'm not sure that owners really properly understood that the reason that the bills weren't there was because the bank was always holding on to them, because they're not subject to that arrangement between the buyers of the cargo and the bank. So I think it is an area where One, what owners do will be really interesting, and let's see whether P&I clubs, for example, start giving different, they might put out circulars saying, don't accept this, you must deliver against filth lazing, please don't have LOI clauses once the Electronic Documents Act comes in, or we'll see lots of litigation about, the three bases for a bill of lading and whether a document of title is sufficient in itself and has a purpose for security.
So a last question, which I think is a more of a rhetorical one. So comes from probably a P&I club, I would imagine. Why should an owner uninsured if delivering against LOIs so P&I is unconcerned? Although I think you can buy on the market a sole cover, be treated as securing a bank as lender who does take out both alternative security and insurance, and indeed should also, I would add, know its own customer. But I think that's.
I think that is a rhetorical question, but obviously also owners need trade finance to be functioning, because otherwise it doesn't have any business either. And so I think there's always that tension.
Yes. I think we need to move on. There is another question, but I think it's slightly off topic. So we will need to move on to the second half of our discussion, and this is to do with decarbonisation. This is, of course, a very topical topic. There have been a number of developments, both regulatory and indeed commercial. On the regulatory field, we have the IMO regulations and also the EU regulations, the former of which Simon and Koye will be discussing. On the more commercial front, we have the Zero Emissions Maritime Buyers Alliance involving Amazon, Patagonia, and Chibo, and also there's a tie-up between Amazon and Maersk, where 20,000 TEUs of Amazon cargo will be transported, powered by biofuel and methanol. Also very interesting and slightly more visually stunning are the Pyxis Ocean, which Cargill has refitted with sails. And probably even more stunning is the French ship, the Canope, which has, I think, 4 or 6 sails. And this is all with an effort to reduce the carbon footprint of shipping. So I think with that very brief introduction, I'm going to pass the baton on to Koye and Simon to have their debate.
Thank you very much, Chirag. Good morning, ladies and gentlemen. Thank you very much for coming, both online and in the room. So what is the issue? Well, as you know, the IMO introduced regulations to control emission and air pollution by the shipping industry in 2021, and they came into force last year. It's a brave new world which bristles with new concepts and new acronyms: EEDI, Energy Efficiency Design Index, EEXI, Energy Efficiency Existing Index. Some parts of the regulations are directed at the configuration and design of vessels in terms of their own innate energy efficiency, for example, energy power limitation, shaft power limitation. Koye and I are not going to be touching on those regulations this morning. They're going to be dealt with in detail. A man who loves the deep weeds of EEXI is sitting there, James Turner, and there'll be a quadrant event with Norton Rose on Thursday morning at 9 o'clock, which other members of Chambers are speaking at, and which I thoroughly recommend. The concept which is causing the most concern in terms of time charter party risk allocation is CII, the Carbon Intensity Index. Why? Because CII is a measure of the vessel's CO2 production over any given year, and the clock goes back at the beginning and end of each year, based not just on the vessel as a vessel, but on what she does, how she does it, where she does it, how fast she does it, and carrying how much cargo. So it's dependent not just on the vessel's own efficiency as a vessel, but on how it's traded. And that means that CII, to a large extent, is going to be out of owner's control, but is going to be under charterer's control under the ordinary time charter party allocation of rights and obligations. For those of you who are not familiar with CII, I can give a very brief thumbnail sketch. You've got a copy of the regulations there in front of you. I don't ask you to turn them up now, but if anybody is finding it difficult to sleep at night, They make very, very good bedtime reading, and I can guarantee you'll be fast asleep by the time you read this, the formula, mathematical formula for the calculation of CII. But in brief terms, and you can see why there's going to be a difficulty under the ordinary allocation of rights and obligations under a time charter party, the vessel has to calculate its CII at the end of each year. That's based on fuel consumption, distance steamed, time at sea, speed versus distance, volume of cargo shipped. That's a complex calculation, as you'll see if you can look at the clause itself, involving a ratio of carbon dioxide emitted against a concept which is called total transport work undertaken. So what the vessel does in that year. There are 5 ratings: A, best; E, worst, and the IMO pitches a required annual operating CI in the middle at level C. Importantly, every ship has to have another acronym, a SEEMP, SEEMP, a Ship Energy Efficiency Management Plan, which is implemented by the ship and the owners to achieve level C within 3 years. You can be at level D for 3 years. You can be at level E for only 1 year. But if you are at those levels, you have to take special corrective action by changing your SEMP, and that involves the flag state. But at present, and oddly, and something which is latched onto by many charterers in the debates I've seen and have been to, although the CII regulations are mandatory for owners and ships, flag state mandatory, and therefore have to be observed by owners, and we can see what needs to be done by owners, SEMP, and trying to achieve a C rating, there are no formal sanctions or penalties for the owners if they don't comply. And that's caused a difficulty. In the words of Nick Austin of Reed Smith, which I think is a very good quote, the CII regulations are a regulatory shark prowling the waters of shipping, but without the sharp teeth of enforcement.
And as Simon has said, there is this consternation in the market because the rating attaches to the ship, and in the context of time charter parties, the use and employment of the vessel is in the control of the time charterers. Now, there will be some element of the ship that will affect the CII rating, say the condition of the hull, the efficiency of some of the equipment on board. But generally speaking, and primarily, what will drive your CII rating is how you use and how you trade the ship. So you have this battle between owners and charterers, and with any good negotiation, everybody's screaming for balance as to who is going to bear the costs and the risks associated with complying with the CII regime. As far as I can work out, that when you look beneath all the shouting, I think what really transpires is owners want charterers to bear all the risks and costs, and charterers want owners to bear all the risks and costs. And now we have what has been the most significant development in an attempt to deal with that balance, which is the BIMCO CII operations clause for time charters, which is what Simon and I are going to be debating about today.
Yeah, Ms. Koye says there are two diametrically opposed approaches. Owners who have to comply with the regulations and who can't, trying to get a level C, or if you're a blue chip, trying to get level A or level B, but can't do that without the charter's cooperation. And I think what's important is the IMO themselves have stressed in these regulations that these regulations require for proper implementation marked degree of cooperation between owners and charterers. The IMO recognise that they've spread the burden for emission control on both. That's one approach. The owners say, well, you know, it's down to you. You're trading my vessel. I need control over how you're doing that. But then you've got the other position, a very interesting article in the Financial Times 2 weeks ago, a week ago, with traders, which is Financial Times short speak for charterers, saying this is all monstrous. And they're used to untrammeled freedom under Clause 8 of the Time Charter Party. We pay higher, you go where we tell you to go, you do what we say. And coupled with this mantra, well, there are no sanctions, so what are you worried about? It's your responsibility. And in the middle, because as Koye said, there's this strive for balance. BIMCO have tried to devise a clause that recognizes this brave new world of CII and tries to balance out the risks. Or does it? Is it just an owner's clause or a band-aid at charter's expense? And the clock is ticking for 2026 when all of this is going to be reviewed. Now, Koye and I have advised on both sides of the debate, so I'm going to take up one position and he's going to take up the other, but it doesn't necessarily reflect our actual heartfelt views. But we're pretty good actors, so you should get a feeling for that. We don't commit ourselves. So I'm going to start with the owners and the BIMCO position. And it's worth bearing in mind, because some people have said, oh, BIMCO, that's an owners organisation. When you look at the drafting team, for the CII operations clause, you have a lot of owners, but you also have Cargill, BP Shipping, and Rio Tinto. So BIMCO's aim, I was talking to Stinner last night at the event for GenCon 2022, has been to strike a balance and to reflect what the CII regulation says. So I'm in the unusual position for me of actually speaking in favour of a BIMCO clause, which is something which I don't usually do. And if anybody saw us last night on GenCon 2022 at Hellman's, you can see where I'm more comfortable. The starting point, I think, is we've got to stand back. What is the BIMCO clause seeking to address? Don't blame, I would suggest, the drafting committee. Blame the IMO, whose CII measure cuts right across the traditional contractual framework for the use of a ship under a time charter party. As we've already seen, the CII rating is a rating of a ship, yes, but it's almost entirely based on the vessel's trading pattern over the CII year. And under a time charter party, that is entirely dependent, or almost wholly dependent, on the time charters: speed, route, cargo volume, laden and ballast voyages, and the organisation of those. The BIMCO clause seeks to reflect that. And I want to draw your attention to a number of features, and perhaps we can discuss them afterwards. The first feature of the clause in paragraph A is this: there is an express recognition that the CII regulations have to be complied with by the owners and by the vessel. Now you think, well, why is that so important? Because there is this suggestion, really, that because it's got no sanctions behind it and no penalties, it's effectively facultative. It's not. The IMO regulations are flag state regulations and are controlled by flag state regulations. It's all part of MARPOL. So I think that recognition right at the beginning, inevitable though it is, that the charterers have recognized in the clause that the owners have to comply with it, is a good starting point, and holds up to scrutiny the charterer's argument, or some charterers' argument, that as it's toothless, it's not really binding and can be effectively put to one side by the owners. At the heart of cooperation is data sharing. So the clause goes on, and probably will be implied under common law anyway, that the charterers are required to give as much information as is needed by the owners for the purposes of doing their CII calculations. As I say, I think that would probably be implied anyway. And then things get more controversial. Clause C says that the charterers shall employ the vessel, including planning of voyages and fuel, in a manner consistent with the CII regulations. And the words continue, which may require alternative or adjusted voyage or employment orders, instructions, or sailing directions. Now remember, think of your ordinary standard NYP or other time charter party. This is a bolt-on clause. It's meant to be discussed in negotiations and stuck on to an existing time charter party or put in to a new charter party under negotiation. So this clause and clause C has to be read together with clause 8. And you can see immediately that there's going to be a significant limitation on the untrammeled freedom under clause 8. But if the vessel has to meet an agreed CII each year, and it's open to the parties under this clause to agree what that should be. So in theory, one could agree 3 years at D on a two-year time charter party, then the parties have agreed what the agreed CII is. If they can't agree, then it's level C. That's the default CII standard. So that's, I think, one very important part which alters completely traditional risk allocation in terms of orders. And I'll come back to something which reinforces that even more strongly. There's quite a lot of talk about, well, it doesn't really create very many obligations for owners other than the obligations they'd already be under an NYP, under clause 1, under clause 2. But clause F sets out very detailed obligations, and I think that is the balancing up on the owners, which are not make-weight obligations, I would suggest, to exercise due diligence in a whole range of enumerated respects to maximize fuel efficiency. So it's not just a question of maintain the vessel and deliver the vessel in good condition and maintain her thereafter by the exercise of due diligence. The owners have to focus specifically for the first time on aspects of fuel efficiency, which are in some respects quite new. And then, and this is the bit I think which I can see Koye now chafing, wanting to get at me. The only reason we've organised the seats in this way, ladies and gentlemen, is that Koye feels so strongly about the BIMCO clause that we needed the imposition. Chirag standing in the middle. Clause G, and this is the one I think which makes people really twitch because it reads with clause C. This is the right, so think of the complexity of drawing up your CII over the operating or trading year. You're constantly monitoring a whole range of variables: speed, last ballast voyage, weather on last ballast voyage, volume carried on that voyage, volume carried on the next voyage, where's she going, recommended speed by charterers, which route charterers are taking, does the master want to go another route? All of that has to get factored in. It must be a dream for the software engineers and producers. So owners are notionally going to be monitoring that throughout the year. They have to, otherwise they end up at the end of the year, do the calculation. They go, I thought we were on B, oh, we're at E. So there's a right of the owners to call on the charterers to provide a commercial operating plan for the future, the rest of the CII year, if, and then two phrases which I very much like. Classic BIMCO drafting, I think. Oops, I'm sorry, I'm slipping back into anti-BIMCO. The trajectory of the charter party attained CII is deviating from the agreed CII. So if you think of two lines in the superintendent office in Piraeus with the data going in, you've got a line which should be looking at December or whenever your end of year is, which will leave you with level C or whatever it is you're looking for. But the trajectory of where you're trading it and how it's being traded with the charter's orders, that means that the line, well, it won't be doing that. I doubt very much it'll be improving the CII. It will usually be deviating from the CII and therefore looking as D or E, or if you're wanting A and B, C. And if that trajectory deviation gives rise to the reasonable likelihood that the charterers may fail in their obligations under paragraph C, so their voyage orders will not be such as to attain the desired CII, then the owners are entitled to call upon the charterers to come up with a plan. Now, just imagine that in trading terms. It's August. There's a deviation. The charterers now have to come up with a plan to get it back on path for C or B, whatever you've agreed. And that will require a lot of cooperation and possibly change to the future pattern of trading as contemplated by the traders and by the charterers. Because as C has told us, which may require alternative or adjusted voyage or employment orders, instructions, or sailing directions. And if that isn't done by the charterers, or if the charterers' plan is not going to get the deviation addressed, then the owners for the first time are entitled to say, we're not complying with your orders. And that really is a complete watershed change, I think, in risk allocation under time charter. Okay, is the clause perfect? No. No BIMCO clause really ever is. Deviating, well, deviating by how much? a reasonable likelihood that the charters are going to miss the target? Well, that's lots of argument and room for argument there. May fail to meet the obligations? Well, that again, there's room for argument, but if you look in the clause, it's badly drafted because it says may fail in one place and will fail in another. But that's something which I put in for BIMCO aficionados. So is it a good clause or a bad one? I'm going to say, for the purposes of today's debate, that it's a good one. But I think the question really is, and it came out very clearly in that Financial Times article, and the big charters as well as the small charters are going to have to face it. If the CII depends not just on the vessel, but how the charterers use it and how they trade it, how can charterers not be involved in the attainment of carbon emission reduction under the regulation? It's addressed to both parties. That's what the IMO says. Cooperation is required between the two. And so I was interested to read the various sound bites from traders or charters in that Financial Times article. It's the owner's responsibility. Well, yes, in one sense, because they're the ones who've got the rating on the ship. They're the ones who are going to have to comply with the regulations. They're the ones who under MARPOL and flag state regulations have to comply, but only up to a point. And some charters say, well, this is a black and white solution to a problem which is not black and white. Well, the CII, it may be complicated, but it is black and white. So I would suggest that the world, provided that it doesn't all get scrapped in 2026 because it's all too difficult to work out. Some people say that's a possibility. I would say the world is a changed place and balance needs to be struck somewhere along the lines that BIMCO have put it. Now you're going to hear that I'm completely wrong.
I would never say that.
You do all the time.
My position is this. I have to accept that, well, my starting point, my proposition is that the BIMCO terms are too far skewed in owners' interests. Now, I have to accept that the CII regime does cause difficulty in the context of a time charter party. And that's because the rating attaches to the ship, but in reality, the ratings are driven by the use and employment of the vessel, which are in charter's control. And so I accept that owners do require some protection. But I say that the protection available must correlate with the risk and the effectiveness of harm that the protection is there to protect you from. Right? If you look at it as a formula, you would say a balance is equal to, well, balance exists when protection available divided by the risk of harm equals 1. If that equation gives you more than 1, you have too much protection. Less than 1, too little protection. And at the moment, I say that the BIMCO clause gives you way more than 1. So what are the consequences of a ship having a D or an E rating? The first place to look at is the regulation. And Simon told us earlier that there are consequences stated in the regulation. The consequence is that if you're rated D for 3 consecutive years, or you're rated E for 1 year, you have to draw up a list of corrective actions and stick it in your C. And you must then undertake whatever corrective actions that you put in your C. And that's it. That is the entirety of the consequence or the harm that can come to an owner under the regulation. Some people will say, well, that's enough. I say that is harm. I accept that, but it's relatively limited. You can ride around for 2 years, 1 year, 2 years at D, and nothing will happen to you. And even if you do have to come up with a list of corrective actions, what is going to happen? You're going to say, well, I promise to make sure my hull is in better condition next year. I promise to do a better job of speed and routing optimization in collaboration with the charterers. These are not huge, significant, needle-moving consequences for the owner. Some people will then say, okay, well, what about flag state? What about port state authority? Do they legislate or will they legislate for stricter compliance with the CII regime? Well, the regulation doesn't require them to do that. All the regulation requires them to do at the moment, all it does is it encourages flag state, port state authority, and other stakeholders to incentivize ships to have an A or B rating. And that's it. That's all that is required. Now, as far as I'm aware, and someone will probably tell me I'm wrong, no flag state and no port authority has come out and said, we intend to legislate in such a way that the CII regime will be strictly applied. So, for example, your ship wouldn't be allowed into our port if it's D-rated, or you won't be able to maintain your registry with us if you have a D-rated ship. So again, I accept there is a risk that something may happen in the future, but at the moment, it looks rather like that risk is quite limited in terms of punitive action from flag state or port authorities. And then you get to the big one, the one that everyone's really concerned about, and I'll call that the commercial sanctions. When people, the ship owners, are worried that big multinational charterers, especially the likes of IKEA, Amazon, the ones that have made big pledges for reaching zero emissions by 2014, and the big oil and gas majors, will not want to hire vessels that have D or E ratings. Now, optics aside, and I get the optics part, it doesn't make much sense that a charterer would say that I don't want to hire a D-rated ship. And this is for two reasons. The first, as far as I understand the regulations, your rating in year one has no correlation with your rating in year two. So you can be rated D in year one, but because your year two rating is based on the fuel consumption, speed, distance traveled from January to December in the second year, you can have an A rating because you operated your ship in a different way. So you can move rating year by year. The second connected point is that if your rating is determined primarily by the use of the ship, the fact that a D-rated ship is D-rated doesn't mean that it is inefficient. It just means that whoever chartered it last did a bad job of operating it around the world. So if you're really concerned about the environment, it doesn't matter what the rating of the ship is when you collect the ship or when you charter the ship. What really matters is the rating after you've given the ship back. So yes, I can see that some charterers may say optics, because we don't want to be seen to be traveling around the world in a D-rated ship. When one starts to think about it closely, you see that that won't make sense. And perhaps because of that, you've seen some charterers like Cargill expressly say that they won't be chartering vessels based on their ratings. And I expect that many charterers will also be taking the same approach, whether they say so publicly or not. So those are the three ways that the ship owner can suffer or could suffer by having a D or E rating. And as you'll see, none of those are dramatic. The risk exists for sure, but I say that it's a limited risk of real harm to the ship owner of their asset for failing to have a C rating or a higher than C rating. Well, if that's where the risk lies, the protection needs to be similarly limited. But then you go to the BIMCO clause and you have essentially two forms of protection. The first is the right to countermand orders, and the second is an indemnity in subclause J. The right to countermand orders is obviously the controversial one, as Simon discussed. And it obviously cuts across the entire concept of a time charter party. Charterers are paying usually quite high rates for the full control of the vessel. And this clause gives owners the unilateral right, seemingly at any point during the voyage, to be able to stop steaming or slow steam or just refuse to comply with orders because they're worried about their CII rating. Slightly more complicated than that, but that's the general gist of it. Now, commerce can't work in that way because most of international trade, as you'll know, is dependent on shipping windows, delivery windows. People have obligations down the chartering line and down their sale lines that will end up in chaos if the owner can suddenly decide to stop or reduce this, the steaming of the vessel at any given point because they're worried about that CI. Now, I accept that there are some circumstances where that is fair enough. And the one situation where we do see that is where there is a real risk of harm or danger to the vessel, the cargo, the crew. And in that situation, you can see that it makes sense because the risk of harm is very high to give them that sort of significant protection. But as I've said, I don't see the risk in this case of harm to the owners being that high. So you shouldn't have something that is so dramatic that cuts across commercial lines to deal with a relatively limited problem. Now, what I would say you should have instead, I can see that Chirag is telling me that I've spoken too long. What I would suggest that you have instead is a wait and see approach. A lot of this is projecting into the future. Nobody knows exactly how this will play out. And as Simon suggested, there's a chance that it could all be scrapped in 2026. So what I would suggest would make more sense is a clause that deals with the consequences of that actually transpire, the consequences that actually transpire if you're not able to meet your CI. So you have a clause that is similar to clause J, which places there's essentially an indemnity by the charterers to deal with any losses, liabilities arising out of the failure to comply with the CII. That way, if, as I suggest, nothing is really likely to happen, charterers get away with it scot-free with riding around in a D&E vessel. But if something does happen, subject to drafting the clause such that you have mitigation and remoteness covered, charterers will pick up the bill. That, in my mind, provides better balance than the preventative approach that the BIMCO clause has in subclause G. And now I'll stop because I'm worried Chirag will try and beat me out.
Thank you very much. I'll start with a question that's been sent over online. In a short-term charter or a time charter trip, how will an owner prove a financial loss caused by a downgrade of CII rating at the end of the calendar year? And how will an owner ever prove a financial loss if there are no penalties by IMO for a D or E rating?
Well, I think that lies behind Koye's suggested indemnity clause, which is that you're very concerned about not meeting your SEEMP target. Okay, I'm happy to pick up the bill if my owners have caused you not to meet your SEEMP target, ... provided you suffered a measurable financial or economic loss or some liability. Unless you have, push off. Koye, was that the idea behind your clause?
A lot more eloquently stated.
A lot more eloquently stated by you.
Can we please make sure James doesn't ask any questions? I worry about how difficult.
It's too late, Koye.
Voice is so deep.
There seem just to pick on three areas of the sort of host of elephants in the room with this thing. I think the time charter trip point is a really good one.
Yeah.
If your time charter trip is in the middle of the year, or worse still, at the end of the year, you pick it up for a 45-day without guarantee trip on the 15th of December, and the owner says, terribly sorry, I know that my contract says that I'm going to go from A to B, but actually I'm just going to sit at A. In fact, I'm not even going to go to A, I'm just going to sit at Z, because otherwise all the other stuff that your broker has kindly put into this contract with me means I'm not going to make my CII rating. So that's one thing. And it's one thing when you've got a 10-year time charter party to think about how you're going to cooperate together, but time charter trip is obviously a different thing. The second is underpinning the regulation and also the clause is this idea that charterers can change their trading patterns. You know, the aluminium refinery is miraculously going to be moved from this continent to that so that I can meet my CII rating. Yeah, it's just, anyway, it doesn't need to be spelled out. And the third is gamification. You can game this regulation, as I understand it, by extra ballast steaming in order to lower your rating, which obviously, given that the whole point of this is to try and reduce carbon emissions, is a thoroughly stupid idea. But worse even than that, it is data. And Simon highlighted the problem of the issue of data. Now, I've heard it said at one of the sessions about the CII, well, you've got AIS data, so there's a limit to which you can falsify that. But that's simply not so. We know that about a third of the tanker fleet is dark at the moment. And what is to stop a very high level of cooperation between owners and charterers engaged in sanctions-busting trade, fictionalizing their trading data so that they come out with A-star rated ships, whereas who knows what they're in fact achieving, based on entirely made up data. And no doubt there's a Russian hacking army working out exactly the right algorithms to generate that even now. Anyway, there you go, Koye. I haven't actually asked a question.
I was talking to certain of the BIMCO drafters last night at the GenCo 2022, and the clause is already significantly under consideration, the CII clause. And the one reason, and I'm not really sure it occurred to him, was this time charter trip problem. Because this looks fine if you bolt it into a 5-year or an 8-year time charter, possibly even a 3-year time charter party. But if it's a time charter trip 40 to 50 days between A and B, it doesn't really make much sense.
Any more? We've got a question from Yash back there.
I think this is a question for Koye, isn't it?
Yes.
No, I'm just, I mean, there's been a bit of BIMCO hating going on, and I'm just trying.
No, I think they're wonderful.
In a rebalance. So I see the issue with the time charter trip and how the regulations don't really fit that well with that. But in circumstances where you have certain accepted propositions, like the idea of controlling carbon in shipping is necessary, it's a laudable proposition, you're going to need in principle some kind of regulations that try to achieve that. Now these may be clunky and imperfect, but in circumstances where there's no teeth in the shark, you don't have flag states imposing sanctions against people falling short of their targets. Something like clause G here, and it seems pretty nuclear, but it provides an effective sanction, a sanction in circumstances where otherwise you effectively have aspirational targets that if they're missed, there is really very hard. Even if you have an indemnity clause that says provide you've suffered a loss, it will be quite hard to show a loss where fundamentally there's no sanction. So isn't it the case that what this is doing is in circumstances where you can't create worldwide sanctions for this, you are creating a contractual sanction or a contractual right that will then regulate behavior to try to bring carbon levels down.
Well, if I'm chartered, I say it's not your role as owners to do that. If there is no doubt that there is a real drive towards doing better with carbon emissions in shipping, and there are better ways to do it than I think the CII does it. But as a charterer, I'm going to say, well, the one person that isn't going to dictate to me how we do it is the ship owner who is keeping their own commercial interest intact, but pushing it all on me. And then some way along the line, this will get passed down to the customers, the consumers down the line. But the people who are actually, who possess what someone described as the polluting asset are the people who are still in the same condition, the same commercial condition that they were before, which as a charterer, I would say it doesn't make sense. So if you want to create a system that really works, and this is my own personal view, everybody has to bleed. But I don't think you can change something that is that requires radical change by trying to maintain a status quo. And in this case, it would be the owners maintaining their status quo. I think everybody needs to pay.
You say maintaining their status quo. Effectively, if you're a charterer and you have in mind particular types of business, and maybe you don't, if it's a very long-term charter, maybe you don't. But if you do, can't you early on, at the time of contracting, effectively have WYSI software that will work out how much meeting the SEMP or meeting the particular target would cost you? And that gets factored into the hire rate. So effectively, an owner does then share some of the burden of essentially saying, if you want C at the end of this year, That means I can't carry as much stuff as I'd like over the distances I like. And that's going to have an impact on me. And therefore, I'm not going to pay you what you'd like. I'm going to cut it by 25% or something like that.
I think James is going to answer this one for me. Thanks, James. He asked with all the difficult questions.
Oh yeah, I can't remember what my answer was going to be now, but, one of the problems with that, Yash, is that all you're doing then is leaking carbon, because if the world economy requires X trillion tons of cargo to be carried from all letters of the alphabet to all other letters of the alphabet, assuming that that is the state, then if one ship owner is going to say, well, I'm going to reduce my tons carried, then somebody else has got to pick up that slack. And ultimately, the only way that you're going to pick up that slack is by having more ships steaming. So actually, you're not affecting the underlying problem at all. The only way, really, of getting everybody to bleed, as Koye so picturesquely puts it, is, I think, a carbon tax on fuel. And that's a much simpler, much more direct way, going straight to the charterer's pocket, the time charterer's pocket, of getting them to think much more seriously about how they manage their the operation of their ships. And that will pass straight down to the consumer. And then we all have to think about how we spend our money. And the Amazons of this world, who are obviously getting ahead of the game, will have to are already thinking very hard about how much carbon is in their supply chain, which is why they're cornering the market in terms of biofueled ships. Let's not get onto biofuels because that's a whole other topic. But it's but there are much more direct ways of achieving this, as Koye says, than a very complex system, which is imperfect and assumes a whole lot of things that can't be delivered and can be gamed.
Yeah, I mean, I'm just picking up on what Yash said. I think this is one of the cases where the BIMCO clause is really rather good. There are a few drafting glitches here and there, but actually, when one considers the speed with which it came out and the way it actually addresses the CII regulation, I think it really is a pretty good piece of drafting. But the problem is, it's the regulation that's the problem, not the clause. So BIMCO is simply responding to the problem. You can't shoot BIMCO. It's this completely unworkable CII system drawn up by people who have no idea or no regard for how maritime trade actually is achieved and how best to achieve carbon emission reduction in the trade as it actually is. You can't just say, oh, well, you're going to have to change your voyage, all your trade routes in the middle of the year because you have to. It doesn't make sense. So I wasn't knocking BIMCO.
Well, I think if we have no further questions and there are no further questions online, thank you very much for all of you for attending in person and online. For those in person, I think we have coffee and tea in the lobby. So please do join us and continue with the questions. Thank you very much.